Professor Bruce Allen Murphy, the Fred Morgan Kirby Professor of Civil Rights at Lafayette College, and I'm very happy to be talking to you about the First Amendment, how it's decided, how it was created, and how it's been recreated and is being recreated even today. The First Amendment text reads, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people to peaceably to assemble, and to petition the government for a redress of grievances." We're going to be speaking about freedom of speech. And when we talk about freedom of speech, what we're talking about is freedom of expression. We're talking about the idea that there is going to be a protection for all people in the country to have freedom of thought, have freedom of speech, have freedom of expression, and be treated equally among all of the people expressing those views. And one of the things I tell my students starting is that when you read a Supreme Court case, you have to know what you're looking for. And the standard method for analyzing a Supreme Court case is IPRAC. IPRAC. You look first for the issue in the case. What is this case about? It is a free speech case and not a freedom of religion case. If you know that this is the issue, then you're looking for what are the precedents, P for precedents, and you're asking, what cases did the Supreme Court use in the past to decide that issue? And you're trying to figure out, how has this right evolved over time through the decisions in those cases? I like to tell my students that what I do is I look at the facts of the case, I look at the issue of the case, and then I try to find the proper silo, like on a farm. Which silo or category of case are we in? Is this about political speech? Is this about student speech on a public school campus? Is this about speech that is offensive to other people? And then I look for all of the relevant precedents and I try to figure out what the court has done with that issue in the past. When I look for those cases, I am always looking at what was the rule, R for rule. What was the rule that that justice used in deciding that case? Presumably, the court at that time said, this is what people have done in this area of the law in the past. This is what we're doing now. And since we see that the facts are different from earlier cases, what we want to do is we want to have a new rule. From now going forward, this is how we will decide this issue. Once you have that new rule, you can do analysis. Analysis. You can apply that rule to the facts in this case, and you can come up with another result. And what you're doing is you're balancing out the interests between the government and the speaker, or the speaker and other speakers, or the speaker and some other functionality, and trying to decide where is the line in this case between the interests of the government and the interests of the speaker. That's your analysis. If you take the precedents in this area, develop the rule for this case, apply the rule to the facts here, then you can do C, conclusion. This is what the result is in this case. This is what the holding is in this case. But many times justices will say, but I'm not done with this holding. I want to give you some indication of where I think the court should go in the future. Sometimes they are offering what's called dicta, D-I-C-T-A. They're going to give you additional information that will give you a sense of where they think the court will go in the future. So it's always interesting to use the IPRAC system to figure out what the rule was, what the rule is now, and what the rule might be. Now, in this short module, what I want to persuade you to do is go a step beyond the IPRAC system, because I don't think it's sufficient to understand First Amendment free speech, freedom of religion, freedom of press kinds of cases. When you look at the issue, one of the first things that the court will do and must do and can do is they can define what is the right that we are talking about. It's easy when we have a method, IPRAC, that assumes that all cases will be either freedom of speech or freedom of thought or freedom of religion or freedom of press or freedom to assembly. But what do you do if there are multiple variations of the issue in the case? What do you do if the person who's acting is choosing to speak or not to speak, but is making that decision based on their religious views and is making that decision based on their personal thought? Then the judge will have the opportunity to redefine that case by saying, I'm not just going to talk about the issue. I'm only going to talk about this portion of the issue. I'm only going to talk about the religion aspect of this issue, or the speech aspect of this issue, or the assembly aspect, or the symbolic speech. You're going beyond the silos of precedents and cases to redefining the right that is in this case and changing the way that the Supreme Court can drive the decision in the direction that they want to go. And that's why I teach my students not just to do IPRAC, but to add to the beginning point, to expand the I to IRL. Issue, right, level of scrutiny. Now, I will talk about the level of scrutiny later on, but the issue is what's going on in this case. The right is, what part of the First Amendment are we talking about? Are we talking about speech? Are we talking about religion? Are we talking about the press? Are we talking about assembly? What right are we talking about? And once I know the nature of the right, what I hope to teach you is you can vary the amount of protection that the court will give to that right by looking at the level of scrutiny that the judge is using to lean a little bit more toward that right and a little bit less toward the government's interests. But what we will learn is what the court sometimes does is say, I'm going to lean a little bit more toward that right in this case, but to do so, I'm going to lean against a different right by another actor in the case. And that will explain where I think the Roberts Court is. So the method that I will be using in analyzing these cases will not be just IPRAC. It will be IRL PRAC. Issue, right, level of scrutiny, and then precedents, rule, analysis, and conclusion. That concludes this part of this segment.